So, before we get to the tortuous and serpentine dealings of the 19th century Supreme Court, we need to set a little context. So, let me begin with an assertion. Social scientists suffer from an inferiority complex. Now, perhaps it's the scientist part, the feeling that they're expected to discover some wonderful formula to explain human behavior. Or maybe it's just that a field in which truth is seen to be quantifiable seems to have more heft than one in which even basic concepts can be elusive. In short, subjectivity is a pain. You can never prove categorically that you're right. Now, I remember many decades ago when I was in graduate school, a debate raged fiercely as to whether or not social science could be value-free. Could we take the human values out? For hour after interminable hour, we debated whether or not we could throw off those Marley-esque chains of subjectivity and move into a sort of an ethereal laboratory where experiments would yield quantitative results. As one of my professors said, could a historian aspire to create the equivalent of Newton's laws of motion? Now, by the time I completed my degree, this argument seems to have mercifully receded. Academia talked itself out, something of a phenomenon. A social scientist, it was grudgingly admitted, was not really a scientist at all, but just someone who threw out a hypothesis, which they hopefully had supported, at which other social scientists could then hurl brickbats. Truth would remain intangible, unverifiable, and to some very significant degree, personal. Now, you all may be asking yourselves, what does this have to do with us? Are we really getting CEL credit for this? Well, yes, because there's a group of people who did not get the message. In constitutional law, which is most definitely a social and not a natural science, a significant segment of both the scholarly population and those on the bench have planted a value-free stake square in the center of the American Constitution. Constitutional interpretation is not subjective at all, it is said, but can easily and objectively be discerned from the document itself. As Justice Scalia said in a 1996 speech, I take the words as they were promulgated to the people of the United States and what is the fairly understood meaning of those words. Well, fairly understood meaning seems to be a benign enough phrase and easily understood, but it's actually rather eelish. The Constitution, as every justice knows, is notoriously and sometimes deliberately vague. For example, in Article 1, Section 8, which grants explicit powers to Congress, the final clause reads, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This is a very potent sentence and very wide-ranging, and it was inserted midway through the Constitutional Convention by the Committee of Detail, which was chaired by a South Carolina slaveholder named John Rutledge. The Committee of Detail, by the way, which I discussed in depth in a previous book, Dark Bargain, little plug, were 5 men meeting in secret, charged with drafting a prototype constitution. Now, anyone who has ever been in business or in a law firm understands the enormous power that committees of this sort wield. Whatever they produce sets the agenda, sets the boundaries for debate. Anything included in the prototype takes a concerted effort to remove, and something not in the prototype has little chance of adoption, particularly in this case in Philadelphia, by a group of delegates who had been for 2.5 months in 90-degree weather. The State House was closed, the windows were barred, the doors were barred. They were in this small room. Many of them wore heavy clothes. It smelled, and by August, when the Committee of Detail's report came out, a lot of these people had really begun to dislike each other. In any event, Article 1, Section 8 is sometimes called the sweeping clause, and it was left intentionally amorphous by Rutledge and his 4 fellows, all of whom were Federalists. So the Federalist Party, which was going to be in power, could enact whatever legislation was required to effectively run the country. How then can there possibly be a fairly understood meaning, a quantifiable meaning of necessary and proper, a phrase which was inserted into the Constitution to have no quantifiable meaning? Now, as many of you know, this is no sterile argument. The necessary and proper clause is at the center of many of the challenges currently to the healthcare law. You're doing wonderfully, thank you. And nonetheless, and although history, to say nothing of common sense, has demonstrated time and time again that there is no one immutable interpretation of the Constitution, the current crop of value-free scholars and justices have succeeded in not only setting the tone of jurisprudence, but also enabling conservative congressmen, a number of rabid talk show hosts, and spawning a Tea Party movement privy, it insists, to the document's true meaning. So as a result, any justice who openly admits basing a decision on analysis, or even worse, applies a broad notion of fundamental justice, is derided as an activist, which today has taken on a meaning that is just this side of communist. But who is really the activist? The justice who admits that language itself is a good deal more subjective than the chemical makeup of an amino acid, or one who insists that he or she can indisputably say what an imprecise phrase means? I find this move to certainty, and I find it to be often smug certainty, to be extremely unsettling. And the stakes I consider to be very high. To get a sense of what happens when objectivity, to use Judge Bork's phrase, runs riot, we need only look back a little bit of history. And so, by a happy coincidence, we come to my book. A little scene setting is necessary. As you all know, in the wake of the Civil War, the nation enacted 3 constitutional amendments. The 13th abolished slavery, the 14th guaranteed all American citizens, everyone born in the country, regardless of color, due process of law and equal protection of the laws, and the 15th guaranteed that the right to vote would not be infringed. Now, despite the speed with which these amendments were adopted, they were not particularly popular. White Americans in the North as well as the South were none too keen at sharing sovereignty with 4 million newly freed slaves. Allowing African Americans to vote, in particular, was not even favored by the radical Republicans who controlled Congress. Now, radical Republicans is not my phrase, that's what they're called in the history books. And these radical Republicans, by the way, were not like today's version. These radical Republicans wanted to expand the role of government, expand it significantly, and use its force to guarantee full equality under law, which they believed to be a national moral imperative. So, as I said, even these men were not certain about granting the vote to a population of largely illiterate, socially unsophisticated former slaves. But a constitutional quirk made it necessary. As you all know, in the original Constitution, 3/5 of the slaves were counted for apportionment. Well, after the 13th Amendment, there were no more slaves. So these 4 million black Americans would now be counted in full to apportion Congress. And if only whites could vote in the South, which actually occurred in the 1890s, and the 11 Confederate states were allowed back into the Union, which everyone assumed they would be, and there was some substantial question as to whether or not they had ever really left, there would be more congressmen in the South by virtue of this additional 2/5 of the black population being counted. White Southerners, in other words, would be granted a larger voice in Congress and in the Electoral College by virtue of losing the war. So in the years afterwards, the nation's electorate expanded by about 2 million new potential voters. 2 million, not 4 million, because only males could vote. The amendments did not apply to women. Female suffrage was not even a glimmer yet. Now, since putting something on paper is hardly the same as making it a reality, to give teeth to these amendments, Congress passed a series of laws. They passed a Civil Rights Act of 1866, which gave all Americans regardless of color, right to enter into contracts, among other things, 2 Reconstruction Acts, and 3 Enforcement Acts.